Good evening, everybody. My name is Brian Smith, and I'll be presenting in week 2 on explain when a sign will be used as a trademark with reference to the Johnson & Johnson vs Sterling Pharmaceuticals case of 1991. Alright, the case of Johnson & Johnson vs Sterling Pharmaceuticals hinges on one point, and that point being is that can the use of a patented descriptive term be considered a breach of trademark law, and then where does that distinction lie? Now, in this particular case, the pivotal term in the case is caplet, which is defined as a coded medical tablet, an uncommon but not unusual term amongst pharmacists, where cap is generally short for capsule and let is the suffix for tablet, and it just assumes the two go together. The caplet was patented by Johnson & Johnson and was used to define the coding and structure of some of the oral medications they sold. Johnson & Johnson had patented the term caplet under the Trademark Act of 1955 and used it as advertising on their Panadol and Panadeine product lines. Johnson & Johnson stated that the term caplet was used to define the product, and the term caplet was associated with the brand. The term appears under the title word Panadol, and Panadeine is clearly capitalized. Following an incident which occurred in the United States, where a tablet coating was linked to a death, the caplet was reinvigorated by Johnson & Johnson and printed on the side of its Panadol bottles as a way of a point of difference between the incident and what they were selling as a product. The bottles had the number of doses in the bottle measured in caplets on the side, i.e. the number of caplets in the bottle. Sterling Pharmaceuticals then promptly used the term caplet to promote a product they were selling, where the term was used in the descriptive sense as opposed to the definitive sense. This distinction forms the basis of this case, being that is there a copyright infringement if the term is not considered to be definitive. Johnson & Johnson's argued that Sterling Pharmaceuticals used the term in a distinctive sense, whereas Sterling Pharmaceuticals obviously stated that it was descriptive and used to define the product itself and not to in any way associate it with the Johnson & Johnson's product. A trademark is defined in the Act as a sign is used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from goods or services so dealt with or provided by any other person. But this is where the challenge in the case arises. Sterling Pharmaceuticals agrees that the use of the term caplet is not used to associate with the medication with the Johnson & Johnson's brand, but rather to link it with the publicly accepted definition of the coding presented on the medication. It is argued that the term is common vernacular overseas and would be used to describe specifically not the Johnson & Johnson product, but rather the aforementioned coding and presentation. The argument also hinges on as to whether the term is generally associated with the presentation and style of the medication, or is it the trademark. The term, although not common in the Australian vernacular, would be interpreted where the cap in context would be assumed to be short for capsule, and let would be the suffix as assumed with any other suffix. So as I mentioned previously, the capsule tablet combination. So just to sort of finalise on all of this, the caplet may not be a common word amongst ordinary Australians, but this does not by default deny the term as a definitive word. With that, and sort of linking it back to the start of the case, you would argue that all in all, it would be assumed that a reasonable person would not immediately associate the term caplet with the Johnson & Johnson's product, but would draw the conclusion that the caplet is a term used to describe medical dosage. So linking it back to the topic, you would argue that although Johnson & Johnson's had formed the patent, held the trademark on the term caplet, that the term caplet in use of what Sterling Pharmaceuticals were applying it in would not in any way, or would not be considered to be specifically a breach of the trademark. Thank you.
Created using Powtune.